page 2. There is on page 2, in paragraph 2, highlighted.
Yes, that's my timestamp. I apologize.
Okay, it's a timestamp. That should be deleted. It will be removed. Oh, sorry, page 3.
But on page 3 as well, Chair, if you're there now? Or are you still on page 2?
Oh, sorry, we're on page 3.
The first paragraph on page 3, the last line, the sentence starts, Dr. Gordon responded in the negative and clarified that once the council investigated the matter and the question of ethical behavior arose, I think we should remove that. The teacher would not be able to include teach in any of the schools. So I think we're missing teach in that sentence. It's incomplete.
All right, include teach.
Also, the following paragraph, it starts, Member Hamilton, the second sentence in that. It's quite a bit abstract as well. She noted it was understood that the question on whether a teacher would be able to be reinstated in the case where a charge was dismissed or the person acquitted, that obviously is an incomplete sentence. I think at that point I was trying to highlight the difference between dismissal and acquittal. So that has to be reviewed.
All right, so could you say what the sentence should read, member?
It was understood that the question, the difference between where a person was charged, where a charge was dismissed or a person was acquitted, was highlighted, or something along those lines. But what you can do is go back to what was actually said. This is incomplete. I know for a fact it is incomplete. Also in that same paragraph, Chair.
Well, member, before you move on, so you're saying this, in essence, this should be saying what?
In essence, it should be saying that I understood the difference where there was a charge that was dismissed and where a person was acquitted.
Okay. Carry on.
In that same paragraph, the sentence starts, Dr. Gordon stated, it's in the middle of that paragraph. Dr. Gordon stated that the council needed the power to conduct professional investigations after the court. You mentioned the timestamp, but also after the court is incomplete. I'm thinking that she was referring to after a court hearing or deliberations of the court or something to that effect.
Dr. Gordon, do you recall?
Stated the council needed the power to conduct professional investigations after a court hearing, maybe. I think maybe that's what she was referring to. But it is incomplete as it is now.
Okay, so
page
after
3.
the court hearing, okay.
Page 3, the second paragraph. The third paragraph, Chair, maybe this is a matter of style. Senator Gale shared agreement. I think we can just say Senator Gale agreed.
All right, thank you, member. We'll move on to page 4.
Before you move on, Minister, just if we could recommit the point made by Member Hamilton about the court hearing. I suspect the proper word would be court decision, because there could be many hearings. But I think you're looking at the finality of the court's decision. So may I suggest that?
Okay, Member Hamilton, that seems like a better...
Sure, Chair.
Yeah, the decision. Yes. Yeah, all right. Thank you, Member Brown.
You're welcome.
All right, we'll move on to page 4.
Page 4, Chair. Third paragraph. In the middle of that paragraph, the sentence starts, Senator Braham noted the referenced regulations provided for the situations outlined, for which he noted with certainty, I think with is missing, that consideration would be given. Are you there, Chair?
Yeah,
Okay.
all right.
The following paragraph as well.
Uh-huh.
Senator Braham noted the possibility where the tribunal that would conduct the proceedings might adjourn the matter in its discretion. I believe it's upon the commencement of a trial.
So you're saying Senator Braham noted the
Possibility where the tribunal that would conduct the proceedings might adjourn the matter in its discretion. I think we should remove after and replace it with upon the commencement of a trial.
Okay. Thank you. We'll move on to page 5.
Page 5, Chair. First paragraph. The sentence starts, he shared that there were some court matters that took years and the matter would be adjourned accordingly. I think we should remove where. Accordingly, after there was an acquittal because the witnesses migrated to another country. Remove where.
Thank you.
Next paragraph, Chair. The sentence starts, she stated that the clause was now broken out to include subsections which specifically indicated the suspension was done upon the conduct of an inquiry. So I would remove after and upon in that sentence. Are you there, Chair?
Change the next upon to
Of an
Of,
inquiry,
yeah.
yes. And further, and below that, the following sentence. Senator Braham sought clarification on whether subclause 60, subsection 4, subclause 4, was to be read with the suspension occurred because of an inquiry or suspension occurred. I believe we should remove where and keep after an inquiry was conducted.
All right, thank you, member. We'll move to page 6.
Page 6, Chair. The paragraph under subclauses 61, 3 to 5. The sentence starts, he noted, it's almost at the end of that paragraph, that the structure of the provision gave the impression that a person who was imprisoned could immediately, I believe we should remove follow and replace it with furnish the requested documents.
Thank you, member. We'll move on to
Also
page...
following,
Yeah.
Chair, the next paragraph, the sentence starts, Member Cuthbert Flynn in the middle of the next paragraph shared her agreement. I believe we can just say agreed. And the very same recommendation would be made for the following paragraph in the sentence that reads, she shared agreement with Ms. Wilkins. I believe we can just say
Yeah.
she agreed.
I agree, member. All right, we'll move on to page 7.
Page 7. First paragraph starts Member Green. stated there were a wide array of offenses that would fall within the category of imprisonment for 2 years or more, which the committee should consider. Remove B. The third paragraph, the middle of that paragraph starts, she clarified that, I believe we should remove with. She clarified that a more detailed definition or vestment of the council with some discretionary powers would prevent the lockout of such persons. I believe we should remove the word with in that sentence.
Move the word what?
She clarified.
Oh, yeah, okay, I took it.
Yes.
Yep, thank you, member. All right, we'll move on to page 8.
Page 8 here, the first sentence, the chairman highlighted that the term disqualifying, I believe we should remove that. Include the chairman highlighted the term disqualifying offense meant the person was disqualified from teaching. So currently it reads, the chairman highlighted that term disqualifying offense meant. Remove that, replace it with the.
All right, we'll move on to page 9.
Page 9, Chair. The paragraph that starts, Senator Gill indicated he wished to see the list of prescribed documents. Senator Braham questioned whether it was needed to state. Remove was.
Senator Braham questioned
Whether it was needed to state.
Okay,
Yes, so remove was.
okay. Thank you. Page 10.
Chair, going back to page 9, apologies. The last paragraph. Second sentence starts, he said as an example that after the end of the process where the employer would have to pay 10 years worth of service, I believe it could be amended to read, he gave an example that,
Sorry, what paragraph, member?
the last paragraph on page 9, Chair.
Okay. So
He
you're saying
gave as an example the end of a process where the employer would have to pay 10 years worth of salary. I think that's what it should be amended to.
All right. And finally, page 11. No, we did page 10, didn't we?
Page 10, Chair.
Oh, okay, sorry.
First paragraph. Senator Gale noted his agreement with Senator Braham and stated the case considered a private institution that was exposed and not who was exposed. And in that same paragraph, I think maybe the third to last sentence starts, Dr. Gordon stated that the teacher had to be paid. I believe she was referring to a teacher that was reinstated, but based on how the sentence is structured, it was, I think it should read that Dr. Gordon stated that such a teacher had to be paid.
All right, thank you.
In
member.
the third paragraph, Chair, apologies again.
No
It
apologies.
starts, Senator Braham stated, the second to last sentence in the third paragraph. Senator Braham stated that there might be a policy decision. I believe this must state, Senator Braham stated that this might require a policy decision. So the sentence should read, Senator Braham stated that this might require a policy decision.
Okay. Thank you, member. Page 11. All right.
So move, Chair.
That's it. Thank you so much. Would the member move for the acceptance of
I
minutes
second, Chair.
held on
Having
Thursday,
gone
June
through
8,
that
2023?
very accurate.
All right. We will turn now to the second minutes of the meeting held on Thursday, June 22nd, 2023, starting with page 1. Moving on to page 2. Move on to page 2. Page 3. Page 4.
Page 4, Chair. Second paragraph, the last line, she indicated that they were the inquiry, remove that and the.
So it should read, she indicated where the inquiry depended?
Yes.
Right. Okay, thank you. Page 5. Page 6. Note on paragraph 1, 2, 3, 4, 5. Just a little bit of a typo in the middle. Page 6. Page 6. Where it begins upon an inquiry. I don't know. Was that a quote, a direct quote? Upon an inquiry conducted under section 53. The Professional Practice and Conduct Committee may, depending on the nature of the seriousness of the complaint, make any of the following decisions. Was that a quote?
Yes.
A direct quote, okay.
That was Mr. Foreman reading a particular clause, Chair.
Okay.
But I think at the end of that, the quote should be a closed quote and not an open one.
And the dash. I don't know. Okay.
Yes.
All right, page 7. We move on to page 8. Page 9. All right. Ask for confirmation of the minutes.
So move, Chair.
Thank you. Second.
Second, Chair.
All right. Thank you.
Chair, just before we move off the minutes, just the experience of these 2 minutes, may I suggest that, and I know it's difficult for the parliamentary staff, a lot of work being done, short staff, but if some proofreading can be done before the minutes are circulated, it would make our work a little bit more efficient. And I urge that consideration be given to that.
All right. Thank you, member. We'll move to...
Chair, before you move, just a recommittal to absence and apologies. Member Braham had indicated to me that he had court this morning, so he could not have made it.
All right.
So he sends his apologies.
Thank you. Matters arising from the minutes? If none, we will move on to matters.
When you left and you asked me to assume responsibilities as chair, in going through, and I want to direct us to the minutes, starting on page 6. That area that speaks to subclause 71A to C. And I read from Mr. Foreman shared that it was understood that the PPCC was the entity that made the decision in relation to disciplinary matters that came before the council. He noted, based on the outline understanding, that the role of the council was to ensure that decisions were effected, such as communicating the decision to the parties or the registrar as the case inquired. He then went on to seek clarification as to the reasons to go to the council. And of course, Member Hamilton would have indicated what she understood the council to do. Mr. Foreman indicated from the description given that the PPCC took the decision for the teacher or the instructor to face disciplinary sanctions. And he noted that it was recalled from other changes made that it was indicated in the reference to a disciplinary sanction that it was from other sanction that it was the decision of the PPCC and not the council. It was his view that the council was the more abstract entity, whilst the PPCC was the tailor-made entity that decided whether a disciplinary offense was made out. He further went on to state that upon an inquiry conducted under Section 53, the council, the Professional Practice and Conduct Committee may, depending on the nature and the seriousness of the complaint, make any of the following changes, and we know what those changes are. That would have been in the following paragraph, the second to last paragraph. The discussion continued on page 7 substantively, where Ms. Wilkins then noted, and this is the second paragraph now on page 7, Ms. Wilkins noted that a matter referred to the PPPC upon which a decision was reached was then conveyed to the council and would become a decision of the council, and the council would take the actions that flowed from the decision taken. She said that in communication of the decision, the council communicated the decision and any actions to be taken in respect of the employee. Consequently, of the decision would be done by the council. She explained that the PPCC was no longer involved in the process once it made the decision. She then went on to express uncertainty on whether it would be casted or framed as only the decision of the PBCC going forward. So, Chair, there would have been discussions around the role and functions again of the two entities. But in this case, the substantive argument was around who was actually making the decision. And what is the role of the decision maker? Now, in my understanding of how the bill has been framed and consistently going through, we had made a decision, no pun intended, that the PPCC would have been, having gone through the adjudication or the hearing, make a decision on the matter and submit that decision to the council. Correct, colleague? And then the council would take the necessary action. So concerns would have been raised around who really makes the decision. And so I think I'm suggesting that based on the concerns raised by Mr. Foreman, and Mr. Foreman is online, I believe. Again, he has the opportunity in your ear to further seek clarity as to the understanding that he wants, or the interpretation that he would have arrived at based on the deliberations that we would have had. But I think at this stage, again, in order to make the legislation as tidy as possible, if there is any ambiguity in terms of the scope and functions of the two committees, we ought to, as a committee, distill it and be clear on the understanding and objectives of the intention.
Member, you said two committees? What two
When
committees?
I said the difference between the role and function of the council and the role and function of the PPCC as it relates to the decision making. So, Mr. Foreman, if you may, sir, you can again raise what you would have raised in seeking clarity on the matter.
Good morning, everyone. I don't have much to say in addition to what's in the minutes and what Senator Gale has just rehearsed. The nutshell of my intervention was to say that the bill had been reformulated over time to place the decision-making in relation to disciplinary matters in the hands of the PPCC, and to have those decisions then being appealed to the appeals tribunal if a party is dissatisfied with the result of the disciplinary process. So that in the provisions related to the ability of a person to appeal a decision, it occurred to me that the better way to phrase that provision would be to say that where a person appeals from a decision of the PPCC, the person does so to the appeals tribunal.
Mr. Foreman, if I understand you correctly, you're saying once this appeal goes to the appeals tribunal, you're wondering if it is, I'm not so sure, the ruling of the PPCC that would be appealed, or something from the council? I'm sorry, I wasn't following that last part.
So at the last meeting, there was a recommendation to change. I'm trying to find the provision, but the provision that speaks to appeals to the appeals tribunal. The recommendation was that the wording there should be changed from a reference to the PPCC to a reference to the council. And I had a difficulty with that because the scheme of the bill now is that the PPCC is the entity that deals with disciplinary matters and takes decisions in relation to disciplinary matters. So that if a person is appealing a decision, for example, to strike them from the register of teachers, they would be appealing a decision that was made by the PPCC. And in those circumstances, it strikes me as the more sensible thing to do, to refer to the PPCC as the entity that makes the decision, or that made the decision against which the person is appealing.
Okay, go ahead, Member Gale.
Can I see clarity on something in my mind, Mr. Foreman? So the decision would have been made by the PPCC, and the decision would have been then transmitted to the council, who carries out the action based on the decision of the PPCC. If an appeal is made on the decision of the PPCC, but the respondent would be the council who would have carried out the decision. So the appeal would be made to the council on the decision made by the PPCC. That's my understanding. I don't know if that's the understanding of the other members. So you would in fact be appealing a decision made by the PPCC, but the appeal would be made on the council. Bearing in mind again, in the commencement of the activity, it is the council to which the complaint would have been made. The council would then say to the PPCC, you now become the adjudicatory panel to hear the issue, and then make a decision and relay that decision to the council. That's my understanding in terms of the approach. Member Brown.
I think so. Member Brown, please go ahead.
Yes, thank you, Minister. I don't want to get into any problems, but in the past I raised the issue of the role of the council, the PPCC, and I used a word like rubber stamp. People weren't happy with it. But are we now removing the council from the disciplinary issues, suppose from the PPCC to the appeal tribunal, bypassing the council? And how does that fit into the scheme of the legislation, which really has the council at the center of it, and the PPC, but a subcommittee of the council? And so I still have problems with the approach being adopted, and I understand my colleague, Senator Gale, raising the issue. What role for the council in these matters? Is it bypass? Does it have a role? Does it receive a recommendation from the PPCC and then acts on that recommendation? And it is that action and the recommendation that then is appealed, or it is no longer, and once a report goes, once a reference is made to the PPCC, the council dies or laid dormant for the rest of the process. And I think that's not the direction we wanted to go when we established the council as this overarching power. I stop at that.
But I thought, from my recollection, and lawyers can correct me, that the report would come into the council. The council would take a look at it to determine, right, where, if they can respond, if an inquiry is required. There are a whole list of criteria of things that the council would look at, right, to determine where next to go with this, isn't it?
Upon receiving a complaint. Yes, yes.
Chairman, remember, the council under the scheme of the bill has other functional responsibilities.
Yes.
So the council is not going to be a sleeping giant. The council in this case, what we thought in applying the provision was to remove the council from the activity of hearing the complaints and creating another organ, this being the PPCC, to be the one adjudicating on disciplinary matters, to make a decision based on the outcome as laid out, and then relaying the decision to the council once again to act on disciplinary matters or complaints.
I agree, member. I see, who is that? Ms. Wilkins, please go ahead.
Good morning, Chair. Good morning, everyone. And as the comments I made seem to be at the center of the present discussion, I felt that I ought to, just a second. Don't know why yes, here we are. I felt that I ought to say, as it was conceptualized, the document that was circulated that set out the composition of the PPCC. The scheme was everything emanates with the council. The council then says to its committee, this is a matter for your attention. The committee has its remit. It knows how it is to go about dealing with matters of this nature, so it deals with the matter. Having concluded its work on that matter, the council, and the document had said it should within 3 working days. The committee, that is, within 3 working days, must advise.
Sorry, Ms. Wilkins, I didn't hear a little part of what you just said. It's a little muffled. If you can just back up a little bit.
All right. It's determining how far back. No, I'm saying, having referred a matter, the council, having referred a matter to the committee has its remit and it knows what it is supposed to do and how it is to treat with the matter. When it's finished, the scheme is that it is to now advise the council of its decision. And I believe the document we had looked at initially said within 3 working days. But the point is, it then communicates the decision not directly to the teacher, but to the council. The council is not supposed to look behind its decision. It adopts the decision as the council's decision, and the council communicates that decision to the teacher. So it's not the committee's decision once the council has received it. And the council now is the conduit between, or that will be used for communication to the teacher. All follow-up action in respect of that decision is taken by the council. So I don't know that we can treat it as something that the committee is independently going to do.
Chair,
it starts with the council and it ends with the council.
Chair, I believe that is the understanding of the committee as outlined by Ms. Wilkins. I think that is the approach that we've been taking and that we understood we want the bill to say. I don't know if, based on what Mr. Foreman is saying, the bill is saying something else, but if that is so, then we need to amend it. We need to fix it. But the approach, the direction that Ms. Wilkins just outlined, I believe is the direction that we all thought we were heading in.
I agree with you, member. Mr. Foreman, did you want to? Oh, Mrs. Okay, SG, please go ahead. Mr. Foreman, I'd love to hear from you as well.
No, I think I'm gonna thank you, Chair. Where's my camera? Sorry. I think Mr. Foreman should go before I do, because Mr. Foreman wants to speak on the issue of the actual policy that is being discussed. I am more looking at what's in the bill and the approach that should be taken once a decision is taken on the policy. So I'm going to yield, if you don't mind, Chair. Thank you for recognizing me.
Yes, please
and
go
good
ahead.
morning to you, members. But if I can just yield to Mr. Foreman, please. Thanks.
Right. So, Mr. Foreman, we just want to hear from you specifically with regards to what Ms. Wilkins just said in terms of how she outlined it.
Thank you, Chair. What I will say is that on my read of the most recent draft provisions in relation to what happens after the PPCC makes a decision, it's not a situation where there is an adoption of anything. It's a situation where, and just to read the clause, upon receipt of a report from the Professional Practice and Conduct Committee, the Council shall serve a copy of the report on the two persons itemized there. And the framing of these provisions reflects a policy that says that the PPCC is the entity that decides disciplinary matters, and the Council carries out the decision by way of informing the parties and the registrar as well acts depending on the nature of the decision. What I hear coming from the committees are a slightly different policy intention, which would involve the council proper in assessing the decision of the PPCC and then making its own determination based on the report that's prepared by the PPCC. And if that's the policy intention, there might need to be some tweaks in that. And there are some practical consequences to that approach to the decisions as well. So that would be my response.
So, Mr. Foreman, sorry, I did not think at all that the council, on receiving the recommendation or decision, the decision of PPCC, would then be considering that decision. That's not the scheme that we've articulated at all. Members?
And what you have just said, Minister, is my understanding as well.
Okay. So what we want, what? Okay, SG, please go ahead.
Well, that's the thing. So, Chair, I'm sorry that I'm going to be pedantic, perhaps, but language for me, the words are very important. So I heard some words being used, and it made things very unclear for me as it relates to the legal process. Who is the decision maker? Perhaps I think rather than let us get bogged down on what the bill says or doesn't say, I think it would be good if we understand the policy, and if we understand the policy and the intent, then the instructions can be given to ensure that all the relevant provisions give full effect to the policy. My first question would be, who is the decision maker? Is it the PPCC or is it the council? And just to point out that a decision maker cannot adopt a decision, because then the decision maker is the person who in law is supposed to consider and take a decision. And they must have, that entity must have room to be able to make a full determination based on whatever is presented to that entity. If the entity is only mandated to adopt a decision, it means they are not the decision maker. So again, I ask, the intention, who is to be the decision maker? Is the decision maker to be the PPCC, or is it to be the council? And I looked at the minutes and I noticed, sadly, I was a little chatty at the last meeting. I promised myself I would be less chatty, but I'm going to refer to the actual section of the Town and Country Planning Act, which I was with last meeting. I just want to read something to explain the position I have. So section 28, big A of the Town and Country Planning Act says, the minister may, if he thinks fit, appoint a person or persons, A, to hear where the persons who he appointed doesn't do what they're supposed to do within the time frame, the minister shall hear and determine the appealing question. Here, it is very clear who the decision maker is. The decision maker is the minister. However, the minister can appoint persons to hear the evidence and to submit to him their written report and their findings. What the minister then does is considers everything and then takes a decision. Now, is that the way you want this to operate? Or do you want the PPCC to hear evidence, examine witnesses, take a decision, and then just communicate that decision to the council? That, I think, is an issue that we need clarity on. Thank you, Chair.
Chair, I believe it would be the council that would have the responsibility to make the decision. Based on what the SG just said, it would obviously require some amendments for the bill to have that effect, because that is what we really want. If at the end of the day, somebody wants to challenge a decision, they would not be challenging the PPCC. They would be challenging the council. So if we need to make some adjustments, I believe we should do that, because what was just outlined is, I believe, what we want as the scheme. I was just going to look at the General Legal Counsel, Chair, because it does have a similar setup. They do have a disciplinary committee that hears, but it is the GLC that's responsible for the decision.
Go ahead.
Sorry, excuse me, Chair, just to say with the GLC, if you don't mind, just to clarify though, the GLC, the disciplinary committee actually takes the decision. What the disciplinary committee does is submits a report on the decisions it takes. So the decision-making body is not the General Legal Counsel, it's actually the disciplinary committee.
So who is taken to court in that situation?
It's the person who would have filed. So normally you will have a member of the GLC who would have actually filed the charge against the attorney. So sometimes it depends on who filed I'm calling it a charge against the attorney at law.
SG, are you saying in this case that the PPCC, having heard the matter, would then be recommending its findings to the council for the council to make a decision?
But so that's if that is the policy. Sorry, just to clarify my answer before. The GLC will be named, but it will be ex parte the person who actually submitted who filed the charges. The GLC is named because it is the entity named in law, but you can, if the decision maker in this bill is the PPCC, then that would be the entity that would be sued. Well, it could either be to the appeals tribunal or it could be to full court. As it relates though to your query, Senator Gale, it depends on the policy. So if the policy is that the council is the decision-making body, then the bill would need to be clear that the council refers the matter to the PPCC just for the examination of witnesses, to hear the evidence, and to submit a report with recommendations. So it wouldn't be that the PPCC is submitting decisions, because it would not be the decision-making body. It would be making recommendations based on the evidence it heard to the council. And then it would have to be clear that it is the council's decision, which would mean that the council could either accept or reject the recommendations made by the PPCC, based on good reason, of course.
Okay, so this, just following your train of thought, SG, so this recommendation comes to the council, and then it goes before the 30-odd member board?
Right, so that was the reason the policy had changed. So when Ms. Wilkins spoke of the initial policy was that the council was a decision-making body, but that policy changed because there was discussion about how practical it would be, and that is what Mr. Foreman was alluding to. And I had given him the floor, hoping that he would expound on his views. But anyway, the policy did change because it was deemed, among other things, impractical for the council to be the decision-making body for these types of matters, knowing that there could now be, remember now it's, Senator Gale has talked about the expanded functions of the council. Council will be doing quite a lot of business. And it was thought that you may also now have quite a number of matters, disciplinary matters, going before, well, whichever entity you decide it should go before. And so the policy changed to reflect the fact that it should be the PPCC that would handle these matters. You would staff the PPCC, give it proper resources, and put appropriately experienced persons to be able to hear these matters and take these decisions, and that these decisions would really just be communicated to the council, but the decisions would have been taken by the PPCC. And that policy is more or less reflected in the bill.
The one in which the PPCC makes the decision you're saying is reflected in the bill currently, SG?
That is correct, Chair.
So I don't know that we want there to be just only a recommendation from the PPCC that then goes to this 30-odd member board for the board to be decided on. Yeah. No, that doesn't sound, no, that's not what we want.
Chair, if that's not what is required or desired, then it will be necessary to elevate in the bill the PPCC to almost the equivalent of the council. I mean, this is a teachers' council bill, and the council is supposed to be the superior authority relative to teachers. I am of the view that it ought to be the council who takes the final decision. They ought to be this decision maker, and the PPCC ought to make the recommendation. And of course, the caveat can be put in that it's accepted. In a funny way, it's like the Electoral Commission reporting to Parliament. The recommendation from the Electoral Commission is almost acted on by Parliament, even though there are very strong members of the Parliament who feels that the final decision ought to be that of the Parliament in fact and in law, and not to assume to be just adopting the decision of the Electoral Commission. Or in the public sector, the Public Service Commission sets out an inquiry where certain people, judges and so forth, sits on a panel, then makes a recommendation to the Public Services Commission. And in some cases, the Public Services Commission has to then make a recommendation to the Governor General. And it's not the Public Services Commission who takes a final decision. And so maybe, Minister, we need to ask the legal people to look at how it is done in government, where, just as in the town and planning case referred to by the SG, whether there's a pattern or a template which can be used, which facilitate the decision taken by the council, but in a way which doesn't unduly disturb the recommendation, strong, cogent recommendations from the committee, from the PPCC. So I am for the council being the decision maker. We need to find a route that gets us there without doing the damage that you fear, Minister, which is that 30 odd people may overturn what a specialized committee has looked at. And in the courts, for example, judges' decisions are only overturned in certain circumstances. And maybe from the examination by the legal people, that may be a caveat which is put into the council making the decision. I suggest that because, as I say, I don't believe if it's a subcommittee of the council, that subcommittee should have more power than the council itself. I pause at that.
Ms. Wilkins. Go ahead, Ms. Wilkins.
Yeah, thank you, Chair. I was thinking, I also recall that the committee's concern was to insulate this, when I said the committee, the members wanted to ensure that they insulate this committee in such a way that it is free to do its work, and having done its work, its decisions are not interfered with by the council, notwithstanding that it's a committee of the council. But I'm thinking perhaps what we could consider, SG can indicate if she thinks there are any concerns with this, or Mr. Foreman, a kind of integrity commission type approach where there are functions carried out by particular individuals which are insulated in such a way that the commission cannot investigate into the decision, question the decision in any way, and are obliged to accept the decision and follow through with it. I'm thinking maybe some kind of language that would insulate the committee, but at the same time not do violence to the role of the council in the whole matter. Thank you, Chair.
Go ahead, Senator Gale.
So, Chair, that would be my concern. We have established this grouping as some sort of a independent firewall, and to report its findings and make a recommendation to the council of 32 members. And my concern would be not to start over, having received the report, another interrogation of the matter, and to apply caution where they may wish to vary the recommendation, because in my mind that would create some exposure to risk, having gone through the level of hearing the issue being exposed to witnesses and evidence. For now, a body that is to make the decision to vary the recommendation of the PPCC. So I would ask the technical team to somehow safeguard against any such intentions of a council.
SG, you still have your hand up, or is that an old hand?
No, new hand. Thank you, Chair. So I've listened and I've heard the pleas for there to be some workaround. In every situation that has been cited, there is one decision maker. One. You can't have more than one. And the decision maker must always be free to be able to take the appropriate decision that decision maker thinks is appropriate in the circumstances. Tying the hands of the decision maker would in law suggest that that person is not the decision maker. Because if you tie their hands, the person who really takes the decision then would be the person behind the decision maker. So in law, if that was challenged, you would be looking at the person who was tying the hands, so to speak, of the decision maker. And this is why I really wanted it to be very clear who is the decision maker. So even in the cases of the public service, including police service, recommendations are made. So when tribunals are appointed, the tribunal makes a recommendation. That recommendation is submitted to the whichever services commission, police or public. I'm not going to wade into judicial, police, public service. And then the Constitution makes it clear who the decision maker really is. And this is why, and the reason we know who the decision maker is because that's the person who is going to be sued in court. That's the person who is taken before the full court to examine the decision of the decision maker. So whereas I understand the angst and the plea to find a workaround, you really have to have one decision maker.
All right. Could I ask Ms. Gordon, I know at the level of the school currently, where you have a school board and you have a personnel committee to which matters are referred. The personnel committee does the interrogation and comes back to the board with a recommendation. And then what happens at the board level? The board makes a decision.
Sorry, and Chair.
Go ahead, Mr. Foreman.
Hello?
We're seeing you, Mr. Foreman. We're hearing you as well.
Just to add to what you just said. So at the level of the schools, where the personnel committee makes the recommendation, the regulations say that the board, having received the recommendation, can vary the recommendation as well. So sometimes the boards will deliberate on the recommendation put to it before voting. Sometimes they don't, etc. It varies. But in that scenario, the board is the entity making the decision, and they are free to deliberate on the matter. And in some instances where the board comes to a decision, the decision of the board itself becomes another element that is the subject of an appeal by an aggrieved party. So the parties will, try to impugn what happened at the level of the personnel committee, and then again say that, well, the board acted unreasonably in accepting the recommendation of the committee, etc. So it adds another layer of I don't want to use the word bureaucracy, but it adds another layer to the process. If you have a specialist entity hearing evidence, deliberating, producing a report, and then making a recommendation to another entity, and that entity then being put in a position to decide whether to accept it or not. So just add that to your considerations.
Just a clarification, Chair of Mr. Foreman. Are the personnel committees ever sued, or is it the board, the decision maker, the board that is sued where challenges are taken? Because what I'm reading, depending on your answer, I'm reading that the PPCC would play the role, for example, of the personnel committee.
Right, but on that, the person would be able to make an appeal if they don't believe the decision, if they don't like the decision. That's when it goes to the teachers' tribunal. Yeah, that's where the appeal
but
goes.
that would be an appeal from the board decision, not of the personnel committee. That's what I'm trying to clarify.
Yes, that's correct. That's correct. So it's an appeal against the decision of the board of governors of X school. That's when it goes to the teachers' appeal tribunal. And then if a parties agree by the decision of the teachers' appeal tribunal and they take it to the Supreme Court, it's the teachers' appeal tribunal's decision that's appealed, typically appealed against. So the decision it's the decision makers. The subject of the appeal is the entity that made the decision.
And Chair, if I may, just to clarify or to indicate that unlike the personnel committee, the PPCC, the members of the PPCC are not entirely from the board. So the in the personnel committee, all the members are from the board.
Is that by choice or by legislation? Because I'm sure board committees are allowed to co-opt members, certainly in most boards, unless the legislation.
By legislation. By legislation, the education regulations specify the composition of the personnel committee. So it's the chairman of the board and and two other persons, one of whom must be from the class of person who the subject of the complaint is against.
But in that case where the personnel committee is made up of members from the board, 100% of members from the board, I could see where that becomes the decision of the board, because those are the members. But in the case of the PPCC, the configuration is a little bit different. As Member Hamilton pointed out, it's only 2 members. That would be from the board.
That minister would be giving non-board members, non-council members, even more power than council members. And so while there's some distinguishing factor involved there, I would urge us to take some of the comments earlier of looking at a model, and it's coming from the lawyers, looking at a model that gives the council the final decision-making but precluding them from re-hearing and so forth. So if on the face of it, of the decision of the PPCC, there's an obvious error or so, then that's the point I was making, that the council should not be precluded from commenting on it or asking for clarification from the PPCC, but not because they may disagree with something, says that can't go. So there are ways and means I believe we can find to tie it down. But on principle, I am of the view which says the final decision maker in the law ought to be the Teachers' Council, because that's what this bill is about, the establishment of a Teachers' Council. We can't put another body above the Teachers' Council unless we're going to say in the bill that this body is superior to the Teachers' Council. Thank you.
Thank you, member. Go ahead, SG.
Thanks, Chair. Not sure I agree that because the PPCC would be the decision maker on disciplinary matters, it would mean it is superior to the council. We have an appeal tribunal in this bill. It doesn't mean it's superior to the council. But I understand the point that is being made. Just to clarify though, that although members of a school board form the personnel, or some members of the school board form the personnel committee, the decision of the board does not, the board itself, when the matter is referred to the board for a decision, they don't have to accept what the personnel committee has recommended, even though it's coming from some of the members of the board, because at the end of the day, the board comprises more persons than who would have heard the matter. And it goes back to this whole point of...
Just to say that the members of the personnel committee, right, according, are all members of the board.
Yeah, but it is not the entire board that comprises a personnel committee. It's a subset. It's a chair and I think 2 others. Whereas the board itself comprises more than 3 persons. So when that 3-member personnel committee makes a recommendation to the full board has to sit, discuss, and take a decision. And sometimes the full board does not agree with the recommendations that came from the 3-member personnel committee. And so that full board, when it is deliberating, doesn't go back to the personnel committee. It deliberates at that time and takes a decision. And then you have an appellate process thereafter. So all I'm saying is the full board is not, the hands of the full board are not tied by the recommendations made by the personnel committee. That in and of itself would violate certain principles we have in administrative law principles. And so I'm just trying to be making a point very clear that the decision maker has to be free to take a decision as the decision maker thinks fit. If you are going to tell the decision maker that it must accept a recommendation from somebody else, it is that person who is the decision maker.
Chair, just as SG, just for clarity and transparency in this case, if the council, having deliberated and has formed the opinion that the decision or the recommendation that was made to it, they would wish to vary, would it require reasons for any such variation stipulated in the legislation for transparency purposes?
No,
it wouldn't.
No. So for instance, to have another example, with the delegation of functions, permanent secretaries of are allowed to take disciplinary action, what they will do is have a committee or a tribunal established to hear all the evidence and give a report to that permanent secretary. But at the end of the day, the decision is taken by the permanent secretary. Now, the permanent secretary may look at the report, and even though most of them will use a retired judge, for instance, on their tribunal, the permanent secretary may actually come to a different view. But remember, at the end of the day, you know, the person who is submitting the recommendation is only submitting a recommendation. It's not their decision. So the permanent secretary doesn't have to go back to that tribunal to explain why that permanent secretary is taking this decision. It's a decision of the permanent secretary. And in fact, at that point, once the tribunal has heard the matter and submitted its recommendation, it's functus. Its purpose has been achieved, it's done, and it has no more role in the matter. The role now is that of the decision maker to take the decision. The only time that decision maker would be called to explain that decision is in an appellate process, whether appeal tribunal or court.
Clearly understood, Chair. So in this case, the council would then make the decision and then in turn instruct its decision in terms of effecting it, as in 64.
So at the end of the day, we want robust interrogation of the issues. We want implementation of the decision, as opposed to what we have now, where boards are not as strong as they should be in terms of taking these decisions, right? Right, because at the local level, people know people and things may not happen, personnel committee may not meet, a decision may not come back, you know, it's not being taken in a robust way to say something's happened, let us consider it, let us make a decision and take the action to lead from that. I mean, that's really what we want to see. And we want issues of professional conduct to be considered as well, not just, how would you put it? Not just those kind of major, I don't want to put it that way. Right, not just the criminal activity, which is outrageous, egregious, right? But we also want the professional conduct issues to be brought to the council, interrogated, and a decision made as well.
Chair, just to remind you though that the boards will still have their function as an employer.
Right. No. I agree with you that the boards will still be there.
But they would, and they still would have to take disciplinary action as necessary too. Right.
But then the council is another avenue.
It depends on the complaint, because there are some complaints that would have to be dealt with by the board. There is a provision in the bill now that if the board thinks that they cannot or they wish for the council to treat with it, then they refer it to the council, but the board will still have its jurisdiction.
Right, I agree. The board will still be there, the boards will still function as they do now. However, you and I know that there are many situations in which people don't feel comfortable, they don't think they'll get a decision, and so on. So they have an avenue to write to the council on a matter.
But then
And
it would be for the council to determine the route to take based on the complaint.
As
So it
in
may-
outlined in 51.
Right. So even though that person might think that they will not get a fair treatment of the matter by the board, it is still the board's responsibility to treat with it. So we cannot take that from the board as the employer.
No, I know the boards will still exist with their with the functions that they carry out.
Wasn't there a provision included where the council would act if the board was delayed for a period of time? Didn't we put something in the legislation for that? So in an event, what the chairman is referring to is just making the board and the council effective. I think that's the issue that she's referring to here. Chair, I've been considering all that was said earlier and what you just said in relation to what the scheme should be. If it is, because I'm considering a situation where the PPCC would deliberate on a matter and then it goes back to the board for the board to pretty much approve the recommendation of the PPCC. And where the council, the PPCC would deliberate and then go back to the council. Based on what we've been discussing, it would require now the council to review or determine whether or not they'll accept that recommendation. And I am foreseeing a situation where the council may not accept a recommendation of the PPCC for whatever reason. And we're still right back at square one in relation to the current status quo that we're trying to address. Based on what has been discussed, it would appear that the best approach would be for the PPCC then to make the decision independent of the council if we want that desired effect. Because, I mean, if we go back to a council that may not want to, for whatever reason, implement or execute or approve a PPC's decision then, or recommendation, then it would be frustrating the process. And I'm talking about a 31-member board with majority of those board members being teachers. We have to consider that.
Chair.
Go ahead, Dr. Gordon. 1 second, Member Brown. Dr. Gordon had her hand up. Go ahead, Dr. Gordon.
I yield.
Dr. Gordon.
Thank you, Chair. I have listened with great interest to the discussion. The council is a governing body of the profession, and therefore any matter that concerns any member of the profession has to be decided on by the council. So the council is the ultimate decision maker. As I see it, the PPCC, it gets the authority from the council to investigate a matter and so on and so forth. The conclusions of the PPCC are then fed to the council. Then the council may carry out one of two actions: accept the recommendations of PPC as is, or may not accept with explanation and send the matter back to PPCC. Whatever the concern the council may have, the council would return it to PPCC for further consideration, PPCC would carry out whatever action and return to the council with its final recommendations.
But Dr. Gordon, that's not what we have here, and I don't see how that would work either.
Nothing in there that says that now, you know.
Yeah, and I mean, the PPCC wouldn't be able to review their own decision without more.
You know, the council can get information in between. So a decision is made by PPCC, a recommendation, and it's sent, the recommendations are sent to the council. But there might just be some additional information that the council considers, because now you have the 31 members of the council. And the council should not, this is what I feel, the council should not vary the decision of the PPCC without first sending the information to them with justification, reasons, rationale, and you send it to PPCC. They then carry out further investigation and come back to the council. And that happens in daily life.
Yeah, but with all due respect, Dr. Gordon, that which you have represented just now may have been a practice. It may even appear as an hypothetical situation, but is not prescribed in any provision contained in what we are pursuing as a legislation. Because what you would have just represented, in my mind, represent an occasion that is so substantive enough that you are going to call on the council now to vary a decision and send back the same decision, vary its decision, and send it back to the PPCC.
The council does not vary the decision. The
no,
council
but,
has
all right. It disagrees with the decision.
Right.
I don't want to be a part of a course of a legislation that has so many variations to it. I am seeking to apply a process that is very clear and transparent for those who are the complainant, those who are making the complaint, and those who are representing the issues, and those who have to hear the issues and make a decision. Now, the discussions this morning would have ensued to one where I believe we're very definitive in terms of who now makes the decision. And we're very clear on that. We would have exhausted the deliberations this morning seeking to pursue that clear and precise understanding. But to now go back and to start varying if the thing can go back and who is going to treat with it, no, we can't do that. That seems...
Well, please tell me,
But that is also,
if the PPCC gives the council the decision, what you're saying to me is that the council must accept that decision and move on?
No, the deliberations this morning would have suggested that the council now would have to make a decision. It can vary, you know, but it would, in the final analysis, make a decision. But what are we going to suggest to send back to the PPCC to do?
Well, listen, my issue is if the council wants to vary a decision, then there should be very good reasons. Excellent reasons.
Remember,
and
I
those
asked that
reasons,
question of SG, and SG indicated that there would have been no reason there would be no need to apply any reasons.
can't we be different? We have to follow that process, that there's no reason to apply the need to vary the decision?
Chair, it's almost as though we're saying if the PPCC doesn't provide a desired outcome that the board wants, then the board can always go back to the PPCC to get what it wants, coerce the decision of the PPCC. I don't think I'm very comfortable with that approach. 32 or however many members, there must be some level of transparency, accountability. it cannot be that because a board does not like, the council does not like the PPC's decision for whatever reason, you're going to instruct the PPCC to review it. That's untidy. And even if that is happening now, I'm hoping that that is not something that we continue.
SG, go ahead, please.
Thank you, Chair. And as I've said before, due to Member Hamilton's excellent training at a certain place, she would be able to expound on the certain administrative law principles that we hold near and dear to our heart when we are public law practitioners. Just to say, though, that when it comes on to an appellate process, there are examples where, let me call them a first instance entity would have taken a decision, you have an appeal. Sometimes the powers of the appellate body are to you either agree, you disagree, so you accept the decision, or you vary the decision, or let me use the forensic language. You grant the appeal or you allow the appeal. You can vary the appeal. You can vary the decision. You can, grant, vary the decision. You can decide that the decision was wrong. Or there are times, and this usually happens with regulatory appeals, that the matter can be referred to the first instance entity for a review, but that is usually done in situations where you have some kind of technical expertise at that level. And so the matter is referred for a review. And that even happens with courts as well, where at the appellate level, the matter can be referred back to the first instance court to review the matter again. So there are examples for that at an appellate level, but the problem is we're not looking at an appeal. We're looking at the decision actually just being taken. So big distinction, because normally that will happen after a decision was taken, and then the appellate body would have those sort of powers. Here you're looking at the fact that the decision would not yet have been taken. So the decision maker would not be referring the matter back to the person who made the recommendation to explain, because the person who's making the recommendation should have provided a proper explanation in making the recommendation. And then it's now left to the decision maker to review everything and just simply take a decision.
Thank you, Chair. I've been listening. Oh, I think Lambert had his hand up first.
He had his hand up.
I can go ahead? Okay.
Yeah.
All right.
Who has the floor?
Go ahead, Member Brown. He had his hand.
Yeah. Chair, if this matter comes to the council, it's not that the council don't like the decision. Whether they like it or they don't like it, why it is sent back. That's not the issue. I trust the judgment of jurors. I trust the judgment of boards and committee otherwise. But let's take some examples. Some of them may be extreme. One, the complainant and a member of the PPCC were in school together. One being head boy or head girl, and the other student. I think you can immediately see where there's some judicial review issues concerning that. Let's take a second example. A member of the PPCC taking this decision. Information comes that they are partners in a firm or they are part of a family. That may be grounds for the council to ask them, is this so? And did the issue of bias came up? did a member recuse themselves from the discussion? Because all of these are common law issue of fairness, which would arise. And so, in a situation like that is why I said the council should not be bound to accept every decision that comes out of the PPCC and can't question it and must, pardon the language, must just stamp it,
Member
rubber
Brown,
or otherwise.
whatever.
Yes?
I think we're past that particular point.
No, I don't think we're past that.
We're just saying you can't send things back to the PPCC. Once it sends it to you,
I don't think.
we're not. What we're saying is you can't send things back to them because you don't like the decision. You take the decision as a council.
Hamilton said that a while ago. I heard Member Hamilton said that a while ago.
No,
I'm saying, sorry?
No, member. Member
That's not what you
Hamilton
said?
is not in agreement with sending things back to the PPCC at all.
No, what I'm explaining is this. There may be a reason when it comes to the decision maker now, who is the council, for the council to say to those making the recommendation, we have had information on XYZ. Did this impact your decision? Did you have regard for the issue of bias, which has come to our attention? So before the council takes such a decision, it queries this thing. And that's why I'm saying the final decision ought to be that of the council. And like the case that the SG spoke of with the PS, that the recommendation comes to the PS, so too the PPCC should be recommending to the council, and the council become the decision maker. That's my position, and the majority may have a different view, but I hold to that, and I wish the record to know that that's where I am.
So, Member Brown, that's not inconsistent with what we're saying. We just
based on the extreme, the example that Senator Brown just gave, in a situation like that, a member of the PPCC would have to recuse him or herself from any deliberations. In the event that that does not happen at the first instance, it is my understanding that should any recommendation go to the council, then all the council would have to do is reject it. I don't know if it is accepted, then that person would appeal the decision.
Go ahead, Member Morris.
Thank you, Chair. I've been listening intently. And, I heard your discussion around the goals, and I wrote them down, which was, you wanted to have efficient disciplinary procedures in place that were fair and transparent. But I also heard SG, and SG was saying that we can't tie the hands too much of the decision maker, the ultimate decision maker. I think it was clear to me before we had this conversation that the council was the ultimate decision maker. That's what the intent was. But having heard SG, I wanted to ask if there is any way that we can have some kind of ring fencing around the decision that's coming from PPCC so that the council can only vary within particular areas. And I don't know, I want the legal minds to tell me what that could be and if there is precedent for that. Because if we do have the council, we don't want the council to re-adjudicate everything and to question everything that had been done before. You want it to accept it or deny it, but there may be certain instances where there may be a role for variation, and there could be in restricted cases. And that's where I think I would be more comfortable in terms of the council not having, carte blanche ability to vary and reject. So I wanted to know if there is anything that we could do in terms of the languaging in here that would give effect to that.
Thank you. I think based on what I heard, it sounds as if the council is the decision maker, which means that the council would be the one to review and take a decision at the end of the day. I'm trying to figure out what is being asked in terms of ring fencing. Not clear on that issue.
One of the concerns, Chair, was that we have a body with 32 individuals who may have varying interests, and the concern was if we have PPCC sending their decision to that council, they could spend quite a bit of time looking back at this issue and not necessarily leading to the goals that we have, which is for us to take decisive action in relation to the conduct of our teachers. And so the question is there a way that we can limit the extent of the review by the council? And that's really the question. Because if there is a concern around the fact that there is this big body that is going to then be looking at the decision of PPCC, that could have the effect of basically, you looking back at PPCC and doing it over again and saying, no, I don't like that decision. Maybe we should vary it in this way and doing this adjustment to it. And what I heard the minister saying and our chair saying is that what we want is for it to be an efficient process, a transparent process, but that we are able to get the goals, and we don't want to get back to status quo where, because of varying interests, we don't get any movement in terms of disciplinary action. And so the question I had was, is there any way that we can limit the extent to which the decisions of the PPCC are interrogated at the council?
So if it is a decision of the PPCC, yes, but if the council is a decision maker, then no. So because you use the word decision. So if the PPCC is the one taking a decision, actually, I'm not even sure what was the next step in the process if the PPCC is taking a decision, because the way how the bill is formulated, if the PPCC takes a decision, the council really just they inform the parties, and then the next step would be an appellate process. And the appellate process gives the power of persons to challenge any adverse decision of the PPCC. If, however, the decision maker is the council, I would say it is not in keeping with administrative law principles to tell the council that they cannot vary recommendations made to them by a body that is not allowed to take decisions.
Madam Chair.
But Chair, in that.
Madam Chair. Yes, please. We are in a world of change, like we're changing every day. We don't want a council that has, although the council is the decision-making body, we have set up a body that inquires in depth and so on in matters of discipline of the council. That body makes a recommendation to the full council. The council accepts, or the council may reject. If the council should reject the recommendation, the council should have grounds, and those firm grounds, and such matters should be sent back to the body that does the investigation into disciplinary matters. That body may come back and say, we have done our investigation and we are sticking with our recommendation. But that is taking away from the council that ultimate decision that although the PPCC makes a recommendation, we are going to change. We don't want that kind of power. We want the body that can carry out the inquiry and so on to be the body that recommends to the council. And when it does so, if there is any reason to want to vary, then that is discussed with PPCC.
Chair, can I recommend that we possibly defer this discussion, move on to the other issues that we have today, because I think we have detained ourselves with this one issue, and we have quite a few others to discuss. So we could possibly just defer this and have this discussion maybe at the end of our deliberations on the bill, possibly. Chair.
Chair, could I amend the suggestion of Member Hamilton?
Yes, I agree, because I think we should.
Chair, I support the idea. You know what I found in these, and it's not confined to this committee deliberating matters, but I found where in other committees where we are intending to arrive at a scope dealing with the fate of individuals around either criminal matters or disciplinary matters, it has become the point of exhausted deliberations, quite rightly so, because you want to make laws that are fair, but also consistent in the approach. And I really believe that, you know, if we have spent exhaustive time today deliberating on this particular matter, and maybe we need to consider, you know, giving it the attention it deserves, but also if the committee and members of the technical team can go back and review in our respective minds the best applicable approach that can be taken to treat with this matter. That includes other policies or even other legislations that might find itself a compatible approach to which, you know, the objective that we are trying to find.
Well said, member.
Chair, I share Senator Gill's position. I proposed it earlier, and I was going to amend the recommendation of Member Hamilton in that direction. I believe that's where we should go. Ask the technical people, in light of the discussion, to review the matter and come back to us.
So, yes, okay. To our technical persons, we're asking you to review this matter and come back to us at the next session. All right, so I know that there are several matters for continuation, but I'm going to ask that we end here because there's obligations of members, graduations, and other things, and that we continue the items on this agenda in the next meeting, plus the whatever findings we can come back with regards to the relationship between the PPCC and the council and how decisions are made, recommendations, and so on. All right. And so we'll move to any other business. Date of the next meeting. So members, Mr. Nash is going to check the schedule and he will put out something in by email. Yes, by email. Today he will put out a notice. All right. So the meeting of the Jamaica Teaching Council Act 2022 is hereby adjourned. Thank you so much, members and technical staff.